I know everyone is super pumped to get into this regulatory panel. So let's introduce our panelists, starting with you, Jason.
I'm Jason Somensatto. I am the strategic legal counsel on the 0x core team. Been a lawyer in the space for a little while, mainly at a private firm, but have spent the last year at 0x just kind of working with the team, and also more generally with like projects building in the DeFi, decentralized exchange space.
Hi, I'm Sarah Hody. I started my legal career actually in litigation and some of the fallout of the 2008 financial crisis. Hated litigation, learned a lot about what was wrong in our financial system, and found my way to Coinbase, where I did a lot of money transmission and financial services regulatory work. And I moved to Perkins Coie about 3 years ago and represent a lot of different projects in the cryptocurrency industry.
Hi, I'm Katherine Wu. I am actually an investor at a New York-based venture fund called Notation Capital. I am not a real practicing attorney. I can't actually say that, but I have a legal background, and I write a lot about the intersection of crypto and policy and regulation.
Awesome, thanks. And I'm Reuben. I used to work at Coinbase for a while as a lawyer and a product manager. I worked with Linda and Jordan and Sarah and plenty of others around. And now I work with a bunch of different startups in the regulatory space. So today, I guess we want to discuss some of the current regulatory news bits that have been coming out in the last few months. But then I want to go a bit deeper into try and get all of you to open up about what we see as some of the real big picture regulatory issues for people building in the space, right? So anyone building crypto applications or products, how can we start thinking at a higher level about the where things are going? But first, I'm sure everyone wants to hear about the SEC. So maybe, Katherine, do you want to quickly give a summary of Telegram, Kik, EOS, just that stuff?
Yeah, in like 2 minutes. That's easy. So I feel like I don't want to repeat too many things, because Linda earlier this morning had sort of given us a broad stroke of all the enforcement actions that happened. I would say, are lawyers better at dissecting these and telling you the future than non-lawyers? I don't think so. But what I will say is I think that the SEC has come down pretty hard this year on some big name projects. Like I feel like a lot of the actions we saw last year were pretty just, I would read the facts and just sort of roll my eyes like, these amateurs, of course. But now we're talking about these like big $1 billion sort of like projects like, Kik or Telegram or EOS Block 1. And I think that carries a little bit more weight because they're such big name players. So maybe with that, let's like dive into the other broader stroke details, because I don't know, we're going to get lost in details if I lay out the facts.
For sure. I think maybe it's just helpful for everyone to understand now, like, the risk that a particular token is a security, and that depending on where it is in its life cycle, right? Pre-launch, post-launch, and maybe that distinction is really important to just make sure everyone kind of understands.
Yeah, I mean, I would say I don't know what a security is anymore in some ways, right? And I'm somebody who started in this space writing about how the SEC might be interested in crowd sales like Ethereum. I think what is confusing to lawyers like me is the idea of a security is a legal construct, right? There is no security in the wild, right? And so when we're talking about a security, in most of these cases, we're talking about a contract, which as lawyers, you spend your whole first year in law school just learning about contracts and how those work. And so from the perspective of something like the EOS settlement, it's fairly easy to look and go, okay, that makes sense to me. It's, this is an initial sale that has contractual terms around it, and it's got all the elements that meet the Howey test, and they didn't go into the issue of what is this native token in the wild. And at least it leaves the discussion open to, right now I think there's a lot of lawyers talking, and I think just in general we use the language of what tokens are securities. And that concept literally just doesn't work in my head when I think about the legal construct of what a contract is. But so I felt okay, we are at a place after EOS where we can still have that discussion. And I think what I found most interesting was after Telegram, it just felt a little differently. Because it seemed to move away from this concept of what we're concerned with is the way you sell these things and the terms that come along with a sale. And really what we're interested in is what is the underlying asset and how are we going to describe this asset. And it kind of adopted a little bit of this concept of the asset itself can be the security. So listen, I don't know where this goes from here. From my perspective as like a lawyer, the way I learn things are either you have a new law that makes something very explicit as to how it describes something, or you have courts wrestle with these very first principles questions. And frankly, right now we're still in a stage where, you know, crypto lawyers are saying one thing and like the SEC is saying something and everybody's got an opinion. And I guess it's a wait until the courts really break down these things, but I just hope that the discussion can shift towards some of this more nuanced understanding of like how do contractual principles overlay on a token, because right now it's confusing.
I would just add to that, I think the notion that we're going to have to wait and see a little bit as to how the courts deal with this is just to take a step back and note that under U.S. securities laws, there are some things that are kind of obvious securities, like equity in a company, but it's fairly unique to the U.S. and Canada has a similar construct that something called an investment contract is also a security, and that's the famed Howey test, so it's probably worth just reiterating. It's the Howey test is whether or not there's an investment of money into a common enterprise with the expectation of profits derived from the efforts of others. And that is a construct that was set by the Supreme Court, actually dealt with like orange groves in Florida. And so this notion of like, what is it, is kind of an ever-evolving question, I think, in U.S. law. So it's both fascinating because it will sort of depend on what the courts decide, but it also is not new that the U.S. has this kind of interesting, we get to sort of decide how a security evolves under our laws take on securities.
So zooming out a bit, like why do we care whether something's a security or not? Like what does this actually mean for people building in the space, people wanting to launch new blockchains?
I tend to think of it, it's like, I actually got this question from a Wall Street Journal writer once, and it was interesting because I think I live in a certain portion of the industry that just thinks about what's happening on chain, right? I actually think you can have different views on this. From people who are trying to create like valuable companies, particularly exchanges and the like, this question is a very practical business question, right? I want to use an asset that, you know, or allow for trading in an asset that is or is not a security. The way the law is basically if it is a security, there is no world in which you can exchange it under the U.S. right now because you need a regulated exchange, you need regulated broker-dealers, all of that stuff, that infrastructure that is not present. So for a business like that, it is, again, just a practical question. What's interesting for somebody like me who thinks a lot about like on-chain transactions is the difficulty becomes in how people are able to actually use the underlying token within the network, right? So when you call a token a security, frankly, you're saying that anybody who holds this or transacts or uses it is violating a law because, frankly, it is against the law for us to deal in unregistered securities. And so it makes the underlying systems not workable. And so that's why I think, from my perspective, it's such an important question, although it is also one of these questions that I'm like, it's going to get figured out at some point, and I just don't know how long that's going to take and if it's going to come out the way we all want it to come out.
Actually, to jump off that and also what Sarah said earlier, like I want to emphasize that this is partially it's a U.S. problem. In the U.S., like financial institutions are one of the most heavily regulated and scrutinized companies like out there, right? And so when you look at digital assets and you group that under like the bulge bracket financial institution stuff, it just gets super scrutinized in the same way, which I'm not even sure makes sense. And partially it's due to like we have a super broad securities law framework, which does not necessarily exist like outside the US, right? Like other countries like Hong Kong or whatever, they have a very like simple, this is security and that's it. And there's no like weird, security contract construct. And I think part of what makes it a little bit difficult is that like I think digital assets are grouped in this little like financial institution in the traditional sense, which makes it really tough. And then B, like the way that laws are written and have carried out for decades, like, I'm talking like 70, 80 years. It's just hard to fit that.
Cool. We're going to have plenty of time for questions at the end. I want to seed 2 potential topics to the audience that we're going to skip over unless anyone wants to really talk about them. One is FinCEN, money transmission, and some of the recent statements by the director yesterday and guidance earlier this year. And the second is IRS, which obviously recently came out with some guidance around forks and airdrops, as well as some tax reporting requirements. So I just wanted to put those out there, and we'll come back. But for now, let's move on to some maybe more interesting topics around, basically in this space, how do you come up with a regulatory strategy when you're building a product in this very uncertain environment? And so I guess the first kind of way to think about it is, and for Jason, how do you think about decentralization as a regulatory strategy?
Yeah, so I thought it was interesting with the DeFi panel earlier, and they were talking about kind of 2 forms of decentralization, right? One coming from like a custodial perspective and one from kind of a political or maybe a legal construct. Like, I don't know, I get torn on this, right? I think like part of the onus on the industry is like, why is what we're building new, innovative, better, right? Because even if it's just non-custodial, maybe that is just a step, but like there's a lot of financial institutions out there that are non-custodial. I mean, frankly, your broker-dealers are essentially non-custodial, right? They don't actually own the stocks, right? And this gets into like a very complicated system, but at least for me, what like excites me, right, is this idea of these protocols and these networks as a global marketplace, and building off of ideas of open source software and some of the earlier network effects around the internet and other things along those lines. And that at least is what feels very new to me. And so if that is the approach or if that's the end goal that we want to get to, like, I think that political decentralization thing becomes extremely important, right? Not because it doesn't make the law applicable, but like the law is what you enforce it to be, right? And if you cannot, once everybody is, holding their own coins and doing their own transactions, the law will necessarily change because it will recognize that it can't impose on everybody individually. And so I think it's actually like really important at least for what I envision as a success in this industry. But I also understand there's a lot of investment, there's a product-driven mentality, and that, decentralization might not meet the end goals of like the users that people want to adopt.
Another aspect of regulatory strategy is finding the right jurisdiction, right? If we think about the way that there is a lot of regulatory uncertainty, especially here in the US, a lot of people thinking about alternative jurisdictions. Sarah, what are some of the issues that are popping up, and how would you think about this one?
Yeah, so when I think about, jurisdictional arbitrage, I think of sort of 2 examples that I'm seeing in the wild right now. The first is on the money transmission side, so thinking about money transmission regulations, and these are basically the same types of laws that apply to MoneyGram and PayPal. They also apply to Coinbase, and the idea is if you're a non-bank financial institution or not an otherwise federally regulated financial institution, there are still state-level laws that are designed to protect consumers. So if I'm a money transmitter and you give me money, I don't just take your money and go to Vegas. I actually either hold it for you or send it wherever you want me to send it. And so one of the things I've seen a lot of more recently is when companies come and they want to engage in activity that would be regulated as money transmission, they take a step back. Instead of saying, well, this sucks, why can't we launch everywhere all at once? They take a step back and they identify what states do we actually care about, where do we think we're going to have users, and let's start there. And so I've seen a trend toward anyone in needing money transmission licenses, taking a jurisdictional approach where they'll say it tends to be New York, Florida, California, Washington, North Carolina, Connecticut. Those are probably the top few states, and then devising a strategy that's like, hey, let's test our product, let's get licensed there, and then expand as we need. The other place I see it, and it's funny because as we were getting ready for this panel, there was one of the questions that was thrown out was, how do you launch a token network in 2019? And I commented, you don't. But there's a more nuanced answer there, which is that one thing we are seeing, and I guess this is also relevant to the question of why do we care whether or not a token's a security, because this notion of an investment contract doesn't exist in securities laws in a lot of other jurisdictions. One of the ways that you can sell something that in the US would be considered a security without having to go through all of the headache of registering with the SEC and going through the various intermediaries is to launch or rely on what we call Reg S. And this is a regulation that lets you sell your security overseas. You have to make sure that there is no flow back into the US, and so the timing on that depends a little bit on what type of security it is, but safe to assume it's a year. But this is a thing that we're actually starting to see as a law firm, is companies who are willing to go launch their network, launch their token outside the US in order to hopefully build enough network activity and decentralization and other applications and distribute the governance sufficiently so that whenever that year or however much time is needed passes and the token flows back into the US eventually, at that point it would not be deemed a security. So those are the two kind of jurisdictional strategies I've seen play out recently.
Yeah, one thing that we like to do as lawyers and like people trying to influence policy is this argument that if there's not regulatory clarity or if the regulations are so onerous within the US, people are going to go overseas, try those markets, try those jurisdictions, and the US is going to be left behind. You kind of hear that, now and again. What's the truth there? Where is that really true, and where is it just window dressing?
My perspective on that is, so far, I don't think that's a major risk, because I think the funding for a lot of these projects to initially get their feet off the ground is still based in the US. And so the idea here is that if you raise from capital, you just do it in more traditional ways. You do your safes, and you sell equity and you raise traditional financing. And I think so far that is still largely been true. And I also think that, well, maybe this is overly optimistic, but I think that the US will catch up before there will be too much that goes overseas. But I say that with having a very US and even Bay Area specific lens. And so I'm also caveat that with a self-awareness of maybe I just have too narrow of a view on that. Something I ask myself frequently.
So going from there, thinking about like a regulatory strategy, which is maybe more the traditional approach, right? Being compliant from day one and building products within that environment, versus a more disruptive or innovative approach, right? Operating outside the regulatory construct until you achieve product market fit, until you have that kind of scale, and then trying to kind of backfill into the regulated environment. Katherine, how do you think about those two approaches?
I think the answer almost changes every year. So like when I used to be asked that question, and I think even last year I would always be like, oh, well, look at like Coinbase versus like Binance, right? Which actually isn't so much of like an argument anymore, because Binance like shut down US and they relaunched as like a compliant like US arm. And then you also hear these like, circles like, well, we can't operate here anymore, so we're going to shut down. Now we're going to sell off Polo. And I think like it's not really like move fast, break things anymore either. I think it's like, look, like I think there's been enough either actions or enough precedents at this point, or whatever, like non-binding, no action letters that really, like, if you're launching, and you joked about this, right? Like, don't launch it. What to do to like to stay compliant? Don't launch a token project in 2019. There's more clarity today around the things not to do. Now, we don't really necessarily know what the right thing to do is, but we know what not to do. And so like even like the earlier things that you thought maybe Binance really can get away with like just serving US customers as is, maybe not really anymore. You could look at like Bitfinex fighting the New York courts, the same thing. And so I think like projects and exchanges and anything that's starting in 2019 just has to be, I think, off the bat, much more thoughtful and careful, because you really can't pull the whole like, oh, well, this has never been done before, there's never been penalties here, and so I didn't know better thing.
Yeah, I mean, to think about like the progression from Satoshi, right? A guy who was completely anonymous, who starts this up, and like, listen, Bitcoin is what brought me into this space. It's what fascinates me, right? But like, you can go back to 2009 and argue about how Bitcoin was a security because it was, centralized. We can do all of that stuff, right? To like Blockstack basically marketing its compliance, right? And that's no offense, like I don't know enough, but like when I read their circular as a lawyer, I'm like, yeah, I've read companies do disclosures to the SEC all my life, right? But they're using it as like a marketing tool of like, it's such a big swing, right? And so I think that's really like, what are you trying to build? What's the path? And I think the key, I think you hit it right on the head. The further along this line we get, the more thought has to go into that, initial staging and how compliant you are, right?
So if Satoshi were to publish the white paper today, what would you recommend they do?
I mean, like, I would recommend to do the same thing. My point would be you would have investors who wouldn't be interested if you didn't bootstrap your adoption. You would have, like, just, listen, you can run a couple nodes on yourself, but the whole point of these is to build the network effect. And the network effect necessarily means you're out there marketing or promoting. And, like, his marketing was, comments on an email thing that, like, spread kind of word of mouth. And, like, our marketing is a guy in the marketing department, right? And it's like, that is a fundamentally different approach, but it's like nobody's going to get the benefit of that anymore, which some people might think is like the ultimate protection against Bitcoin, right?
Yeah. Or you see maybe people like set up SPVs and put in 100 mil to pre-mine things. It just, I feel like Bitcoin was like it's hard to replicate that today.
There was a bit of an uproar on crypto Twitter in the last couple of weeks when Joe Wiesenthal from Bloomberg said something like, basically the only use case for Bitcoin is transactions that are illegal or transactions that the man doesn't want you to do. So illegal or grey, whether it's, buying drugs on the internet or making donations to WikiLeaks. And so a lot of people were kind of offended by that statement. But it's interesting to kind of think about like how as lawyers you kind of respond to those allegations.
I mean, I have a couple, this is where I feel like we should have started with all of the I am not your lawyer disclosures, right? But I think there's some truth to that. I think people talk about censorship resistance as sort of a goal of a distributed network, a decentralization, and that's really quite true, and that's part of what adds a lot of value and what makes it so that you don't have to trust intermediaries. But it is also what makes it scary for governments and what makes it probably most appealing in the early days on the fringes. And so I think that, much like you could argue that a lot of why Netflix is a good streaming service today is because of porn sites in the early days of the internet. Bitcoin was used for a lot of really illicit, bad activities that even in countries where, there are really restrictive governments and good kind of noble reasons for Bitcoin to maybe exist or censorship resistance to exist, that's not what Bitcoin was used for in the early days. So I think that's always going to be a criticism, and maybe it's because people who have the ability to get involved in these fringe industries also are the ones who are like watching the newest and latest technology to stay ahead of governments or stay ahead of regulations. Maybe there's some cause and effect there. But I, at the end of the day, don't see it as a bad thing. I see it as going back to, what's your product market fit? What are you building that is going to either make a network more scalable or more decentralized, or build an application that people are actually going to use? So at the end of the day, I think just because some of the use cases are illicit does not mean anything, is like morally wrong with the industry.
Cool. Anyone else?
I mean, I guess I would just say that, so I'm from DC. I basically spend a portion of my time doing like policy work and dealing with people either on the Hill or regulators. And I don't think probably the people here in San Francisco fully understand how direct of an opposition it is to say we're going to make sovereign money, right? That is taking on the government on its very fundamental level, right? Similarly, at 0x, we think of ourselves as kind of an infrastructure layer for like a lot of potential use cases. And right now we are highly focused on the DeFi wave because it's kind of where the interest is. But from like my perspective, that is a tough approach in the sense that like finance is an extremely highly regulated area that the government has a very big interest in keeping control of. And so when I think about it, it's like, there's just multiple strategies to go about here. I'm huge into like the NFT gaming space. Like I would love if we could do leverage longs on Cheese Wizards instead of on, like Libra or whatever, right? But, so I think there's different attack angles, right? Like ultimately though, the goal is to break down some of those barriers, whether they're put up by the US government, whether they're put up by other governments, that at least to this industry don't make a lot of sense when we're talking about a global marketplace. And how you get there, whether you take them directly on their level, which I'm saying like is gonna require a stronger like policy push from this industry than probably is there right now, or if you kind of like try to sneak in the back door.
We should probably talk about Libra real quick. So how do you think about Libra in that context, right? Is it coming in from the inside? Is it coming in from the outside? And how's it going to play out, Katherine? No pressure.
I have mixed feelings on Libra a little bit. I think on one hand, I think people who are in crypto, I think it's hard to be like, I hate Libra and it should never exist, because at the end of the day, like the idea of like cryptocurrency is not mainstream, right? Like maybe people know what Bitcoin is, but like barely, right? And introducing the idea that like money is digital and money doesn't have to be backed by your government is actually more radical of a thought. And I think, I take it almost as granted now, because I think being in crypto, being surrounded by people who believe in the same thing as I do, I don't even think to question it anymore. But when you talk to people who aren't in crypto or come from more traditional like backgrounds, the idea that like money has to be backed by a sovereign government is like very, very like deep rooted, right? It's like in their belief system. So Libra. And then the reason, Jason, you talked about this earlier, like it is directly oppositional, right, to where governments think their role is for good reason, because that's the way it's always been. So on one hand, look, I think there is value in rooting for Libra as a way to introduce this sort of like non-sovereign backed money to more people. But of course, the sort of like cyberpunk and like, part of me that brought me into Bitcoin, like obviously hates that for other reasons. But it's hard to say it's going to be like super detrimental. I think if anything, it's like an approachable way to approach the idea of cryptocurrency in a non-sovereign backed setting.
Yeah, I totally agree. So you also kind of had a bit of a spoiler earlier of a question I really wanted to ask, but I think it's a great question. So are lawyers any better than non-lawyers at predicting the legal future? And why or why not?
So I have maybe a biased perspective, which is to say that I think if you're at a law firm, you maybe have a slight edge, simply because you're working with enough clients to know what issues they're dealing with that may or may not be public yet. But I think that only puts you at a time horizon of increasing your ability to predict things as a matter of probably months. So if you're sitting here, and I would put that at like maybe 2 to 4 months, because that's like the life cycle of, I think, where people end up either launching or pivoting or changing ideas or reshifting priorities. But as far as like what's going to happen in a year from now, maybe even 6 months from now, I think I agree with what you said earlier. I'm not sure that we're any better at predicting. And I think the reason is because there are so many different forces at play. Part of it is just we've got at least 3-4 major U.S. agencies that are influencing kind of how we're all thinking about it, not to mention enforcement actions and what's happening internationally.
Yeah, I would think we're probably not much better at predicting what like a regulator would do, right? Because I think you have to understand like the way the regulatory system works is it responds to the market, right? So you can build the craziest crypto derivative decentralized exchange that like violates every law in the world, but if you and your buddy use it, like, okay, cool, right? Like there's not going to be a lot of, and so that's why like like that's what Libra did, right? Is it took an idea and it put it right in the forefront, and like what we probably have a difficult job of doing is figuring out where the market's going, right? Any better than anybody else, right? Like I didn't know Facebook was going to like publicly take its position right to Congress and like try to argue that like what it's doing is kind of should have an easy path. And so but I think what will be more interesting is if we do get to a point where like courts are looking at this thing, because I think that is where you'll get I mean the federal judges in this country are usually still fairly well considered in terms of like bringing a pretty objective analysis to these things. I also think these are really hard concepts to understand. And so my guess is like if you saw some court cases, like all the discussion would be at the nuance that like crypto lawyers are thinking about it, and not the way that the industry is like, oh, that's a security, it's centralized. It's like we would have very like detailed discussions about what is a contract, and like maybe we're better at that stage, but I don't know when that comes, right?
Awesome. All right, I want to make sure we have plenty of time for questions, so shoot. All right, at the back there.
David recently said that Facebook was considering switching to dollar-backed and euro-backed stablecoins, and I guess I'm wondering, that feels like that gets rid of the sort of like existential threat to national currencies, but is Libra still interesting if everything's just dollar-backed stablecoins? How is it any different than what we have now?
I think the answer is yes, because look at USDC and look at Tether and every other, look at DAI. I think there's a market for dollar-backed stablecoins. And the reason I think it's interesting for a company like Facebook to do it, I don't know how many people in this room use products like Venmo and PayPal and Square Cash, but frankly, like my favorite way to pay friends is through Facebook Messenger, because they have the most seamless, like money lands right in my bank account. I don't have to like go into the app and then transfer it out, which is an annoyance that you have to do if you use Venmo or PayPal. So I think it's interesting not only because it's a big name, but it indicates if they integrate something like a USDC, which is essentially what it would be if it's a dollar-backed coin, and they make it so that I can equally pay my friends in London. I think that's pretty cool, and it makes it mainstream, to your point, brings it into the public eye in a way that Bitcoin and a lot of us in this room haven't reached yet. Yeah, so it could, and I guess that's maybe I mean, we could probably talk on an entire panel about what that might mean, but it would have its own implications. I think it would have the ease and the integration if it's coming from a brand that we already all use. So that's what I mean on the upside there.
Yeah, the interesting thing about Facebook is not that it would have a token, it's that it would have a wallet in everybody's freaking Facebook account, right? Like that's where they win, at least relative to the current market.
I'm actually going to ask you a very controversial question. So in your mind, and you obviously, if you don't want to answer this question, you don't have to answer this question, but in your mind, is stablecoin or a concept of stablecoin is virtual currency? And the reason why I'm asking this question is because I spent 20 years working in financial services, and so to me, majority of the stablecoins out there look more like an open loop or closed loop cards, right? So if you go back to the old FDIC guidance. So given that backdrop, do you think it's virtual currency?
I mean, I guess so much depends on your definition. I think that's what's crazy about the token world, right? Is that it can bend your mind. Like I didn't catch, you said it was like a prepaid card or something like that,
Open loop.
If you go back to the old regulatory rules, and if you look specifically at the guidance that came out from the Federal Reserve and the FDIC, you'll see that stablecoins as a concept is very similar to open loop and closed loop cards, prepaid cards.
Sure, and like as a securities lawyer, I can see
and then you go back to the definition of what is a deposit.
Right.
Very broad definition, right?
But so like this is like as a securities lawyer, I go back and I'm like, oh, this looks a lot like a collateralized note or a repo or something along those lines, right? Like I think we can kind of overlay one of the hard parts, I think, for being a lawyer in this space is it looks like X, so it is X, right, kind of thing. We do that with securities. We do that with a lot of things. And I think that's made it easy for people to pick out regulatory schemes that they think they want it to fit into. And, like, I guess my feeling is, like, it's good because it brings the conversation to kind of like a first principles discussion of, like, really, what are we talking about here? We're talking about, like, a notch on a ledger, maybe backed by somebody else's bank account. Like, that's something new. It's a warehouse receipt. You can compare it to so much, but for like how you regulate stablecoins, I mean, I will say, like, we saw there's like a draft bill that just went around today of, like, all stablecoins are securities, right? It's probably not going to pass, but it is definitely an idea that got floated out there about an hour ago, right? And so, like, but I think the interesting thing is you can kind of port whatever interpretation you want over some of these concepts.
Yeah, and in some ways it's ironic we're coming back around to this, all these questions again with stablecoins, because the same kind of questions we were confronting in, like, 2014 and 15 is, like, is Bitcoin like a prepaid card, right? Is it a voucher within this network that can be used? And so arguably stablecoin looks a little more like that, but ultimately, to Jason's point, it's like, are we trying to just regulate by analogy or argue by analogy rather than consider the actual underlying use?
And I'll just add one more point to that, which is to say that a lot of these terms that we use colloquially are not well defined in any law. So we say stable coin and we all kind of think we're thinking of probably a dollar coin, right? But, like, stable coin could also be tied to an amount of gold, or like Libra's original kind of idea is more of a basket of currencies and assets. And so as with probably all tokens in this industry, they're actually all kind of hybrids, and we don't have great names for them, partly because they're all hybrids. And so I think that's true. Even if you look at USDC relative to DAI, you'll see different iterations of even a US dollar denominated stablecoin.
Yeah, I think, one of the first things you learn in law school is that a normal word means a different thing to normal people and to lawyers. And so we're actually still so early that we're arguing over definitions. Like, this is why when you read, Kik, or you read, like, Telegram, their defense is like, oh, okay, this is a token, you're saying it's a security. Actually, no, we're a currency, right? And so because we're a currency, we're actually not a security. So it's all these, like, currency, security. Like, what are these definitions? And I think there's actually some argument to be made for both. I think it's just like a legal definition battle right now. And lawmakers are confused.
I think everybody's confused. And I also think, like, what's so tricky is, like, we're trying to put a legal definition on something, like, let's assume it's an ERC20 token. Like, from the 0x exchange perspective, nobody gives a shit what the legal definition of is, right? Because what matters is that we were able to put it into a format where it can be kind of seamlessly traded. And so that's where it's really testing the legal limits, because the law is used to kind of, like, things moving independently or not moving too quickly or only moving through regulated intermediaries. And as soon as you can move a token, with the snap of a finger, some of the definitions become a little bit irrelevant in a way,
And another reason why I think definitions matter is because depending on the definition, it's a different agency, it's a different regulator, it's a different set of laws. That just adds to the confusion.
Is there time? Yeah, we've got. All right. So I want to ask a question that's less controversial. I was kidding. So just going back to Libra, I'm sure a lot of you guys have followed. There's 28 companies within the association, and you saw there's about 4 or 5 companies exiting, or at least, if not exited, in the process of exiting. You also have heard there's various countries like Germany and China that are against this currency. So I was just curious, do you see any regulatory or compliance challenges? That's kind of the first part of the question. And secondly, do you see the success of this, Libra? And if so, how long would it take to kind of cross all that, dot the I's and cross the T's?
I see all the regulatory issues with it, which are tons, right? Because whenever you're dealing with real-world assets, that's when the legal constrictions are there, right? If you say, I'm going to hold a basket of currency, right? Like, that is a super highly regulated world that you live in. And then to trade something vis-a-vis that, like, yes, I think the regulatory hurdles are somewhat huge. Do I think it's successful? This gets to a weird thing that I think is more like, I don't know, do they care what the regulators say, right? It's a power play, right? You can say, they can say all the time they want, I am here to follow every regulation that you put out. But if the SEC says, we think it's a security, well, then their network doesn't work. So are they going to listen to that? Or are they just going to launch somewhere else? Are they, is their idea if we get enough adoption that like the regulators have to listen? And this gets into a very weird situation I don't think we've seen very much, which is a company as big and as massive as Facebook can compete with governments if it wants to, right? Which like maybe not the US government, but like other governments, yeah.
Well, they can elect the US government.
Well, and I also think it's worth noting that a company like Facebook is one that's probably not as shy as a lot of the startups that have been working so far of the U.S. court system. So they have deep enough pockets to fight it more than probably the average company that's working on a crypto project.
Got time for one, maybe two questions.
While we go there, I just want to prime you guys for a final question, which is, with the caveat that lawyers aren't necessarily any better at predicting the future, what's one regulatory development that you'd expect in 2020? So why don't we go to another question first?
Okay.
It seems like the cadence of regulatory action has been picking up this year. Is there a good analog for an industry that was legitimatized by greater regulatory bandwidth?
I mean, do you consider like the derivatives market like legitimate? I guess so, right? There was like a period of time, Connor can tell you much better over here, that like derivatives were basically fully unregulated in a certain way, and it was kind of, now there wasn't a retail aspect to it, right? And so there was a lot of efforts to kind of bring in regulatory regimes that would create kind of the modern derivatives markets that we think about. From a retail perspective, though,
I mean, maybe money transmission a little, and I'm thinking of on the state side, not so much federal. So this is actually to the definition conversation. State money transmitter regulators care about consumer protection. Federal money transmitter regulators care about money laundering. So they actually are very sometimes overlapping, but very different regulatory goals. But I think from the state perspective, the money transmission laws actually all started as remittance laws. And so if you don't read, or if you don't read English, English isn't your first language, maybe you don't understand very well, the money transmission laws were all designed in the remittance context to make sure that people were giving appropriate disclosures and disclaimers and receipts, and making sure that, if I can't really understand the person I'm talking to very well, I at least have like something that a receipt that I can go back with and be like, why didn't my money make it to where I told you to send it? And that in the internet age, actually, like PayPal, I think was the first company to take that to the digital space and say, okay, if I'm moving money for you, well, you know, in your eBay transactions, I'm taking your money and you want to know what I'm doing with it and make sure you have recourse if I don't do what I say I'm going to do with it. And since then, it's also evolved into crypto. So it's maybe somewhat analogous.
Yeah, I think like every financial market is the history of regulation, right? Like there is no financial markets without like regulatory definitions, because what you're doing is ultimately a legal act, right? Like a legal construct world. So it's like, even if you look at the origins of the stock market, right? It's like this Buttonwood agreement. You have like these guys who just want to come together and make deals together, you know, and ultimately that leads itself to 29, and then you have the crash, and then you have a regulatory response to that, right? It's like inherently these things are going to kind of go back and forth with, you would have none of this regulatory action if you didn't have 2017 in the ICO space, right? In some ways. So I think it's a bit of a chicken and egg of like what's causing what. You know.
All right, should we finish up with some quick predictions?
Katherine?
They don't have to be controversial.
No, I mean, the one topic we didn't talk much about here that like is the AML one, which is like, I go back to like, I tend to think the securities law question is a short-term question. Now, what's your definition of short-term under the law? Could be like 5 or 10 years, maybe longer. But that ultimately we'll get some clarification as to like what a digital economy looks like from a regulatory perspective. What I think is the harder fundamental question behind all of this is, like, do you have to identify yourself in a transaction, right? Yesterday I was in DC at a conference where the director of FinCEN, and the guy just basically like angrily yelled at the crowd, is like, you must comply, like, stop, and I was just like, they asked some nuanced question about like decentralized finance, and he's like, you know who you are, you must comply. And like, he's like, all we want is your name, your address, your phone number, blah, blah, blah. It's like, that's all we want. And it's like, for a privacy-oriented crowd probably like this one, it can seem crazy. And so I think that is where the ultimate policy debate is. And so whether I guess I would predict some action by an AML regulator that gets at least crypto legal Twitter up in arms. So.
I will go with, and I'm like 50-50 on this, but I'm going to go with we will see more cases in court.
At actual court as opposed to regulatory actions.
Yeah. So rather than agencies doing enforcement actions or publishing settlements where they were exploring an it feels like an enforcement action to the company, but the net result is it gets published that you've settled by the time anyone finds out about it. I think we'll see things in, U.S. district courts.
All right, this is super cop-out, but I'm just going to say instead of 6 months, I think that's going to be 12 months before we see like a trial in court with like a jury and everything.
Cool. Thank you all, Katherine, Sarah, Jason. This was a lot of fun. Thanks.